Is there any possibility of trying to fix it? You know, try one more time to fix it, but if you can't, you need to get out. Then the next day, I met with Barbara Peterson, who was the president of the First Amendment Foundation. She's also an attorney. She and I are very good friends, and you will recall earlier in my narrative, I met with Barbara right after the creation of the foundation. She's the person that actually introduced me to Marty O'Boyle. And I was very concerned about how this might impact her, because the Citizens Awareness Foundation I had, with the approval of the board and Marty O'Boyle's direct approval, I had agreed to sponsor the First Amendment Foundation Sunshine Seminars, which they do each fall, and they do 10 of these around the state, and they're very well attended. In fact, they're approved by the Florida Bar for CLE. It's a big deal, and we were going to pay for everything. We were going to provide box lunches for all the attendees and give away sunshine manuals. We were going to pick up the tab for everything, and as part of that, we were going to get acknowledgement that we were paying for it. And this was very important to me because the First Amendment Foundation is so highly regarded by the legislature. I mean, if there's new legislation that affects public records, the first thing that legislators do is they call Barbara and find out, is this good or bad? It's a big deal. She's taken very, very seriously. In fact, she was the chairwoman of the Governor's Commission on Open Government Reform. I mean, she's a big deal. And the idea that we would be able to be aligned with her, and during this time, by the way, I actually participated in a press conference of equal billing with Barbara. I mean, I had really worked very hard to affiliate the Citizens Awareness Foundation as much as I could with Barbara Peterson. And
with legitimate officials and legitimate public interest.
Yeah, absolutely, yeah. I mean, not in a manipulative way.
No.
In a we're right. On the same side. And I was concerned that, as you know, I had worked so hard to do that, and Barbara had been I think, allowed me to do that because of me, not because of the foundation, because of my relationship with her. I was concerned that I may have put her in a position that might cause her some embarrassment. So she was meeting with her board in Tampa on June 12th, and she was kind enough to meet with me at the hotel in Tampa. And I started describing to her what was going on. And she had almost the verbatim, "Why are you still there? You need to go." But again, with the same sort of, this has potential to be such a wonderful thing. Is there any chance of fixing it? Maybe you ought to take one more crack at fixing it, but if you can't, you need to go. And I think her exact words were, if they won't do what you want them to do, you need to tell Marty O'Boyle to go fuck himself. She cusses like a sailor. Delightful lady. And a very dear friend. Ironically, when I was meeting with her, I got a phone call, which I did not take. And when I got up to the parking garage of the hotel, I returned the phone call, and the phone call was to Bill Ring. And Bill put Denise DiMartini on the phone and Jonathan O'Boyle. So it was a conference call with the four of us. And this is at the Intercontinental Hotel in Tampa. That's when the conversation began, and the conversation did not end until I'd almost gotten all the way home in Lakeland. So we were on the phone for about an hour. And the conversation resurrected an issue that had come up once we started getting involved, the foundation started getting involved with litigation against state contractors. While we were litigating against publicly operated agencies, municipalities, and state agencies, the firm had been pretty good, I think, about just asking for their actual hourly billables and expenses.
This is not a conversation with the law firm regarding any legal advice.
There wasn't a single lawyer on it. The only people who were on this phone was Jonathan O'Boyle, who is not a lawyer in the state of Florida, and Denise DiMartini.
And your board.
And Bill Ring, who was president of the board. So there's nothing privileged here. What had started happening was, once they started litigating against contractors, who are notoriously bad actors when it comes to public records access, what they were doing was demanding flat monetary settlements. When I say flat, I mean just pick a number. The problem that I saw with this, and I raised this issue repeatedly with the board, and this was the purpose for this conference call, if the O'Boyle Law Firm's actual fees and expenses are at $250 an hour, let's say, or $1,500, and they demand $5,000 from the defendant, and the defendant agrees to pay that, what happens to the windfall, the difference between their hourly billables and expenses and the total number? My reading of the Florida Bar rules is that that would constitute a contingency fee arrangement, and that a percentage, not less than 60%, has to go to the client. The problem is, I had told state legislators and reporters that the foundation was not profiting from the litigation. We don't get any of the money. Well, Jonathan's solution to that is, fine, we'll keep it. Well,
That's what he said to you.
yeah, oh yeah, we got into it over this. In fact, this issue had come up before. There were several instances where Giovanni Mason, one of the attorneys at the O'Boyle Law Firm, was engaged in settlement negotiations and would call me. He was a good attorney, a straight arrow, trying to do the right thing, and he would call me and say, look.
Well, are you going to get, is this lawyer-client, or is this with the foundation where you're asking for advice?
Yeah.
Okay, don't.
Let me just suffice to say, this wasn't the first time this issue had come up, and I had made my views on this very, very clear, that if you're going to claim attorney fees and expenses, it really has to be your attorney's fees and expenses. You can't be anything more than that. And what I have told attorneys is, if you've got $1,200 in fees and expenses at this point, I think it's perfectly fine to tell opposing counsel, you know, today I'm at $1,200. It's going to take us probably another hour or two to wrap this up, so I'm going to add, you know, another 2 hours to this, and I'm estimating we're going to close this out at $1,700. I think that's perfectly fine, as long as you're communicating to them what you're doing. What I'm not okay with is suggesting in some way that your fees and expenses are $5,000 when they're really only $1,200.
And that's what you believe was occurring?
I believe they were either suggesting that, if not outright saying it, or they were not saying that and just saying this is a monetary settlement for $5,000 and keeping all the money.
And
either one would be a serious bar violation.
Did they provide the foundation, when you were there, did the law firm provide you with any closing statements?
I have never seen a closing statement, ever.
Have they ever provided you with any documentation showing how much they collected in fees on cases that were settled?
Never.
Have they ever sent you, while you were at the foundation, a schedule of any expenses that they incurred?
Never.
So you've had no financial reporting from the law firm at all?
None, and I made it very clear to them that my understanding, and I feel very strongly about this, is that they have a very clear obligation to have a written fee agreement, and at the close of every single case, I would have to see a closing statement.
And sign it, right?
That's correct, that I would have to approve the closing statement, and that it was a very serious bar violation to disperse any funds without the client agreeing to the closing statement. That they can't pay themselves, they can't pay anybody until they presented a closing statement, and I've agreed to it.
And did you tell Jonathan O'Boyle that?
I did. I told Jonathan that, I told Ryan that, I told Giovanni Mesa that, I told Hannah that. Hannah and Giovanni Mesa, I think, were very much in agreement with me. I think that Ryan, to a very large extent, was in agreement with me. There was I'd be privileged, I can't say that.
I appreciate that. Let me ask you this: Who was the bookkeeper who ran the accounts at the firm?
It would have been Carlo McCletchan.
Okay, and when the firm advanced costs, were those monies put in trust from the foundation? Did the foundation give money for the?
No.
They came from the firm itself,
Yes.
or from Mr. O'Boyle? You don't know.
Not from the foundation that I'm aware of.
Okay, so they were.
I mean, I had actually suggested at one time, because you know, think of Marty as the bank. You have one guy who he's either loaning money to the firm or he's giving contributions to the foundation. But the money's coming from the same place either way. My suggestion at one time was that instead of Marty loaning money to the firm to be used for filing fees, that he simply give that money to the foundation, and then the foundation would make litigation grants. I proposed that because I thought it would be it would add some validity to what we were doing, and that I would be in a position to be able to make those grants on behalf of citizens who wanted to litigate, which I thought was useful for a number of reasons. One is there are lots of people out there who simply don't have the means to litigate. I thought it would make the whole thing that we were doing seem much more legitimate if you have more than just one primary plaintiff. I mean, if the Oboyle Law Firm has 6 clients and the Citizens Awareness Foundation represents 95% of their caseload, that might look, if not inappropriate, it might look fishy. We'd be far better off if we were willing to help individuals and other organizations, other civil rights groups, to be able to do litigation by giving them the grants. And I didn't get any traction with that suggestion.
So after you had this 1-hour conversation where you were, I take it, arguing as to how the firm was attempting to pay itself or paying itself, or how Jonathan Oboyle thought the firm should be paid, what occurred?
Well, I was pretty near apoplectic. I mean, I was really animated about this because this was a really, really big issue for me. Partly because if the foundation was going to get any of the money, you know, it's going to damage my credibility with reporters and with legislators who I have assured this is not what we're doing. If, on the other hand, the foundation, the firm is just keeping this windfall, I think that's a very serious bar violation. You just can't do it. And they kept telling me that they had an ethics opinion.
Okay, don't. There was a.
Well, this isn't privileged because what I'm going to say is not privileged because Jonathan Oboyle, who's not an attorney in Florida, said this to me and to the board of the foundation. So I don't think this is in any way privileged. In fact, they sent me a copy of it, so I know it's not privileged. That there was an opinion letter from an attorney, Kevin Tynan, who they kept talking about as being this amazing, wonderful, highly regarded ethics attorney, who said all this is okay. And my response was, I've talked to 13 attorneys who say that it's not. Well, our guy knows what he's talking about, and he knows what he's doing, to which I responded, well, I could paint any hypothetical to any attorney I want and get the answer that I want. I mean, you know, it depends on how you ask the question. I suspect that if I were to describe to this guy what I believe is going on, I think I'd get a very different answer than what you're getting.
Right.
And they were really adamant that that's not the case, that this is okay, we want you to agree to do this. And I was like, there's no way I'm going to agree to do this. And the way I left it with them is I'm willing to be, the way I think my exact words were, I'm willing to be disabused of my opinion. But until I am, we're not doing it.
And were any cases on behalf of the foundation settled by the Oboyle Law Firm?
Oh, yeah.
How many?
I have no idea. Because they were engaging in settlement negotiations without my authority.
Okay. And
I mean.
And you've never seen any closing statements, you've never signed any closing statements while you were there, and while you were there, they were settling cases on behalf of the foundations and not accounting to the foundation.
Right, and what I told them, and just so I'm clear, I've worked with many attorneys over the years on public records litigation, and as I said, Greg Thomas, who is not in any way involved with any of this nonsense, is the standard by which I measure all other attorneys. I would trust Greg with $1 million cash. I'd trust him with my life. I think he's just as honorable a man as ever been a member of the bar.
It's nice to know there are attorneys like
there are a few of them out there. But even with Greg, as high as my regard is for Greg and for his firm, I insist that I see every communication. If you're going to communicate with opposing counsel, I want to see it. Without exception. I want to know what's going on. And part of it is intellectual curiosity. One of the reasons why I think I have some expertise in this on this field is because I've taken that approach. I want to see what's going on. If there's a hearing, I want to go. I want to be involved with every step of the process, and I communicated that same expectation to the O'Boyle law firm. Yet they did not do it. And that becomes very clear when they are engaging in, not only are they settling cases without me knowing about it, but they're not even telling me that they're engaged in it. I haven't even authorized a settlement.
And they're asking for more in fees than they're entitled to, and not even agreeing with you in a written closing statement what's happening with the money.
Right. Bill Ring told me on more than one occasion, and this is a quote, "It's none of your fucking business how much money they're getting."
So that's what he told you when he was president of the foundation?
Yes, it's none of our business what they're getting. If they can get $10,000 for a case where they only have $500 worth of work in it, so what? Good for them. Why should you care? And my response was, I care because, number one, if it's a public agency, these are tax dollars that are being spent, and I'm
maybe defrauded.
potentially. And even if it's a contractor who's a for-profit corporation who's getting rich on the backs of the taxpayers by screwing them and not delivering on the contract like they're supposed to, who I'm not very sympathetic towards, I don't want to cheat. I win fair and square. When I go into court and I kick the shit out of some attorney over a public records issue, I do it fair and square. I don't have to cheat. I have really good facts. I don't file unless I have great facts. And that is a very important part of how I operate. If opposing counsels figured out that I had crappy facts and I was, playing on the margins, they'd figure it out very quickly, and nobody would take me seriously.
Okay, so by this point, after this 1 hour conversation, and all the lawyers you met with, did it occur to you that Martin O'Boyle and the O'Boyle law firm were engaging in illegal conduct?
I was concerned about that, yes. I am very confident that if I were to draft a legal instrument for someone who was not an attorney, that would be a felony. That would be unlicensed practice of law. And I have no doubt.
What about if you, as a law firm, ask a government entity for $10,000 in legal fees when you've done $500 worth of work?
Again, I think it would depend on how it was presented. I think if you said our fees are $10,000 when you've really only done $500 worth of work, I think that would not
Anyway, anytime you get money for work you didn't do, you're only entitled, the law firm's only entitled to attorney's fees. There's no money damages in these cases.
Right. I think not to put too fine a point on it, I think the issue is whether you're presenting it as entitlement. I agree with you. Mm-hmm. If you say I'm entitled to $10,000, you have to really be entitled to it.
What if you say I want $10,000 to settle the case? You're only allowed to collect, as an attorney, your attorney's fees per the statute. How could you possibly collect more than your fees under any circumstances?
I think here's the distinction. If we're engaged, if you and I are on the opposite sides of this, and you represent
a government entity, I represent Gulfstream,
okay,
and you've sued.
Yeah.
Okay, and you're the attorney, and you have $500 worth of time. You just filed a template. You call me up, I call you. We admit we did wrong. How can you even say I'll take $10,000 to settle the case? I would
agree with you. I think that would be unethical to do that.
Why wouldn't it be criminal? Why wouldn't it be defrauding the government of money?
Again, I think if the attorney were to claim entitlement, I think it would be.
Well, if the only thing the attorney's entitled to ask for on monetary relief is his fees and costs. So whatever he asks for,
you're asking me to draw a legal
that's legal collusion. I understand, but yeah. I'm sure you didn't really analyze that because they're telling you the whole time this is a contingency agreement. This can be done, but I'm curious.
Well, here's the thing. My issue.
Well, that's not. This isn't for you to figure out or understand.
My issue
You're not a
with what we were doing here, what they were doing here, is that I don't think it's legal. I am confident that it constitutes a very serious bar violation. But even if you were able to satisfy, and this is what I told them in this conversation, even if you were able to satisfy my concerns with respect to, I mean, if you showed me an opinion letter from the Florida bar saying that what you guys are doing is completely legitimate, I would still object to it. And the reason I would object to it is because it creates the wrong perception. We're not doing this to create an economic enterprise. The foundation cannot function in that role. The foundation is here to defend the public's right to access.
Right.
This is,
So you were against it. You were against it on principle, separate and apart from any ethical or legal consideration.
Did I believe as a layperson that there was a very strong likelihood that this was illegal? Yes, I did.
Okay. And so, did you, after that conversation, decide to ultimately disassociate yourself?
Well, the next day, I got a phone call from two of the attorneys at the Depo law firm. And they told me that Bill Ring, Denise DiMartini, and Jonathan O'Boyle called a meeting of the firm and told the attorneys that I had in fact agreed to this windfall scheme. And those two...
They called you and said this, that repeated that you had agreed to it?
Yeah, what happened was the next day, after being really vociferous in my objection to it, I mean, unequivocal...
Epileptic, you called it.
Epileptic. Yeah, I mean, just really almost unglued. In my objection to it, Bill, Denise, and Jonathan convened a meeting of the firm and told the other members of the firm, the other lawyers.
Was Bill a member of the firm?
No.
And was Denise?
No.
And Jonathan's not a lawyer?
Right.
Okay.
They tell the other attorneys, Giovanni Mesa, Nick Taylor, and Ryan Whitmer, that I had agreed to this scheme. And two of the attorneys, who I won't mention their names at this point, but two attorneys called me, separate from each other. One attorney didn't know the other one was calling me. They called me within 10 minutes of each other to tell me that they had said that I had agreed to this. And I was livid. And the reason they called me was because they were like, "This doesn't sound like you. You've been objecting to this all along. This doesn't sound like something you would have agreed to." And I was like, "Hell no, I didn't agree to it. Absolutely not, I didn't agree to it." So yeah, at that point, I have this input from Greg Thomas and from Barbara Peterson and all these other attorneys that I've talked to. Things are just getting worse and worse and worse. And now the board and Jonathan have, I can't imagine there was any misunderstanding about what I said and where I stood on this issue. They lie to the other members of the firm and tell them that I'm okay with this. So yeah, at that moment, I think I probably knew that I was going to have to leave.
What'd you do?
Well, I kind of checked out a little bit. I decided that I wanted to kind of think about my departure. Barbara's counsel, which I took to heart, and Greg's too, was that if I resigned, I needed to do it publicly so I could disassociate myself from the foundation. I feel like one of the greatest assets I have as a civil rights advocate is my credibility. I know there are a lot of people that don't like me. I mean, I was described in one newspaper article as the most hated man in Florida, which I don't mind, but I think that I have a reputation for being a straight shooter and playing fair and
Being respected.
yeah. I mean, that's the reason I get a seat at the table with the legislature.
And that's why lawyers often say, I don't care if I'm loved as long as I'm respected.
Yeah, once you lose your credibility doing what I do, it's over. So I didn't want to make a rash decision. I wanted to give some thought about how I was going to depart, and I very much had the sense that there were other members of the firm who would probably be leaving as well. And
You had heard from other members of the firm that they were leaving
they were very concerned, yeah.
because of what was going on.
Yeah, over these same exact issues. I mean, everything we've talked about today. Yeah, the same exact issues. And chief among those would have been Denise's involvement with the firm.
And I take it, from your descriptions, that Ryan Whitmer was one of the people that told you he was leaving, that he was not
He
pleased
had
about?
actually announced he publicly announced his resignation. Giovanni Mesa has announced his resignation as well.
And
They
there-
hadn't at this point.
But you knew that they were not tolerating this conduct.
They were objecting to it, yeah, absolutely.
And Mr. Ring, did he ultimately become a member of the law firm?
He did.
When did that occur?
I'll come to that in just a moment. So
Okay.
back to your question, what did I do? I said I checked out. What I mean by that is I decided that I was going to, occupy my time doing advocacy stuff and, just try to kind of, I guess the way some people play tennis or go boating or whatever or dance to find some distraction from the work. I went on the road and was working with some civil rights activists and just kind of, not really trying to minimize I was trying to minimize my communications with the foundation and with the board. I was still working for the board and still doing what I was being paid to do. And I was, just trying to kind of collect my thoughts about how I was gonna leave. And then they actually ended up making it really easy for me. Just kind of give you some more things that happened after that. So during after this telephone call on this June 16th, then on the 19th, I was in Jacksonville on this day, working with some civil rights activists. I got an email from Bill and Denise saying that they were resigning from the board of the foundation, and that I was going to be appointed as a board member and I would become president of the foundation. Nobody had talked to me about this. Nobody asked me if I wanted to be on the board. Nobody asked me if I was willing to serve as president. I just got an email saying that's the way it was going to be. And so I called Bill, and for a moment, I had a little hope. I thought maybe they, after me kind of just going silent for a few days, and I was working the whole time, but not really communicating with them, maybe they kind of got the message I was not happy. And I thought, okay, well, maybe they're going to finally let me do things the way they need to be done. And so I called Bill, and that's when Bill told me that I asked him, do I have a say in this as far as becoming president of the foundation? And he just kind of like, no, not really. And then he explained to me why they had resigned. Why they had resigned was because Denise was going to go to work full-time for the firm.
The law firm.
Yeah. And Bill was going to become a partner in the law firm. And that was just one more nail in the coffin. Just like, you guys just don't get it. Remember, I had objected to us using this pre-existing not-for-profit that Marty had created because Jonathan was on the board of it. And because I thought that would look terrible. And now they have the guy who's the president of the foundation resigns to become a partner in the law firm. A law firm that he told me I had to use exclusively. And Denise DeMartini is resigning from the board to go to work for the firm, the same woman that I reported to who kept demanding that I produce more and more lawsuits for the firm and that I could not refer cases to other firms. Then on the same day, I got an email from Jill Moeller, this receptionist at the Commerce Group, with more public records requests that she was making on behalf of the foundation without my knowledge or consent.
So you learned that when?
Same day, on June 19th.
That Mahler was again making, the receptionist is again making public records requests?
Yes.
On behalf of the foundation
Yeah.
without your knowledge?
Yeah, I got 2 emails from her that day acknowledging that. Then on the 23rd of June, they actually file an amendment with the Florida Secretary of State naming me as a board member and as president of the foundation, again without my knowledge or without my consent. Then on June 25th, Jill Moeller lets me know that again she's making, and she's telling me about making these public records requests after the fact. It's not like, hey, I'm going to make this. Is it okay? It's, we made the request. Oh yeah, here it is.
And you tell her you have no authority to...
You can't be doing this. And I don't blame her. She's just doing what she's told. and I want to be clear, Jill, she's a receptionist, she's just doing what she's told.
By Marty.
I assume by Marty. I mean, I don't know who else would be telling her.
Or Denise.
Then, then I get a phone call. And I get a phone call on June 26th. And this is really unusual. I got a phone call from a guy named George Ellis, who is the executive director of a state contractor called Miami's River of Life. And they were being sued by the foundation in a lawsuit that I had signed off on. And the facts of the public records law violation are very clear, and I, to this day, will stand by the facts of the case. And it stands out in my mind because there's only been a handful of times in my career doing this that a defendant has actually contacted me directly, not their attorney, just the defendant. And George, it turns out, he and I are connected about 20 different ways. He's an African-American fellow, and I'm very active in several African-American communities, working with black churches and black civil rights groups. And it turns out we know a bunch of the same people. There's some African-American ministers that I'm good friends with, that he's also good friends with. And this just kind of came up in the course of our conversation. And he said, look, I blew it. You made a public records request. I ignored it. And you sued me, and I realized that I shouldn't have ignored your public records request. I should have handled this differently, and I'm sorry. And then he went on to say, we don't have very much money. Fast as we get a grant from the state, it gets spent. But, I'm willing to try to resolve this with you. And on top of that, would you be willing to work with me to help me better understand what my responsibilities are and how I can do a better job of responding to public records requests in the future? Well, because I care about public records access and I couldn't care less about the money, there's nothing I'd rather hear from a defendant. I mean, I don't know what else I could ask a defendant to do than to say, I blew it, I'm sorry, will you help me not do it again, and let's resolve this. What more can you ask? And he said, so I asked him, I said, well, what have you, what's going on? Now bear in mind, I did not even know that we were in settlement talks with these folks. I didn't authorize any settlement discussions, didn't authorize any monetary demands or any other settlement demands for that matter. And George told me that the Oboe law firm had demanded $4,300. And I expressed to George my